final two cases for this court deal with gay marriage, and in two different parts. This first case deals with a federal law. The second case deals with state recognition. But in this particular case, this case involves around what is known as the Defense of Marriage Act, which was passed in 1996. And what the Defense of Marriage Act did for all purposes of federal law is that when any other law referred to marriage or spouse, so any other law that had those terminologies in it, marriage and spouse would only refer to individuals whose legal unions were between opposite sex couples. In essence, this law, the Defense of Marriage Act, mandated that the federal government did not recognize same-sex marriages for a wide variety of purposes, even if states did recognize them. And so the particular issue in this case, and the background for this, were two women were married in Canada and had their marriage recognized in New York, where it was legal. They lived for a number of years until one of the women passed away and left the entire property, inheritance, and everything to her spouse. Because the federal government did not recognize them as legally married, all of that estate was taxable. Whereas if they had been recognized as legally married, all of it would have been exempt from taxation. And so the woman in this case, Edith Windsor, brought suit claiming that DOMA, the law which required the federal government to do that, violated her Fifth Amendment due process rights. In the interim, some interesting things happen. First, the Obama administration states that they're not going to defend DOMA. They're not going to defend the law, which is a very rare thing for an executive to do. They simply state that we're not going to defend this, and because we don't agree with the law to begin with. It's a very rare stance. So what happened is a group from the legislature, from Congress, the Bipartisan Legal Advocacy Group, otherwise known as BLAG, which is a very dumb acronym, intervened in the case in order to defend the statute. There are some issues that arise with whether the U.S. Supreme Court even had jurisdiction to hear the case. We're going to skip over all of those, in large part because, well, the majority opinion kind of does as well. So even though there are a number of issues in this case, we're really only going to focus on one of the issues. And that was the Defense of Marriage Act, which defines marriage under federal law as a legal union between a man and a woman. Did that deprive individuals whom were legally married within their state of their Fifth Amendment due process and equal protection under the law? Now, this is a sharply divided decision. In fact, this decision and the decision that follows in Oberfell could not be more divided. And in both of these cases, Justice Kennedy writes the majority opinion. Justice Kennedy states that, well, this law is unconstitutional primarily because it treats similarly situated individuals differently, and it puts one group of individuals at a disadvantage as opposed to a similarly situated group of individuals. Now, the problem with this majority opinion, it does strike down DOMA, but the problem with it, it's not entirely clear how they do that. And by that I mean it is not entirely clear by what legal mechanism that they strike down the Defense of Marriage Act. And that is something that those individuals in dissent most certainly bring up. There is a dissent by Justice Roberts. Justice Roberts' dissent, in essence, is arguing the standing part, the part that I skipped over. But he further argues that the majority largely didn't deal with varying definitions of marriage across the state and didn't really handle the true substance of the issue. But his dissent is more focused on the standing issue, thinking that the majority did not correctly address it. Justice Scalia's dissent really takes the majority to task for what he feels is really a standardless review process, that it isn't clear what sort of scrutiny that DOMA was subjected to. It isn't clear in the majority opinion how really they get to the decision they make. Furthermore, Justice Scalia, as does Justice Alito in a separate dissent, think that it is patently absurd to assume that the founders had intended for the federal government to recognize same-sex marriage. That this process by which the majority goes through doesn't address the fact that this right, which is now recognized, and that right being, mind you, only that the federal government has to recognize same-sex individuals who are legally married. But that right, it has no tradition in the United States. This isn't a right that was long held but somehow run afoul in 1996 when DOMA was passed. And so it seems to those in dissent that the majority are just sort of waving their hands, in essence, to declare this law unconstitutional, to declare DOMA unconstitutional, without really pointing to any concrete evidence or any concrete portion of the Constitution which would allow them to do so and which DOMA would run afoul of. The dissents here are blistering because the majority opinion really doesn't provide a significant amount of context into why the court actually decides in the way that they do. And this is something that we will revisit when we get to the next case, Oberfell. While this is one of those areas where the policy end is something I agree with, the majority opinion in this case, it is fairly lacking in that it doesn't provide a lot of context for the decision. It doesn't provide a lot of legal reasoning for the decision. It strikes down DOMA, making the federal government recognize same-sex marriage for a variety of purposes, without really saying very specifically why the federal government doesn't have the authority to do that.